law is a profession that is rooted in society. So you have to see what's happening around you in society and try to interact with people in other professions, people in civil society. You may have cousins who are computer engineers, software engineers, talk to them, understand different things, expand your horizons. So hard work, expansion of horizons, reading, and follow your heart. And there's no one road to success. I think you'll get there eventually.
Hello everyone, we are back again with SuperLawyer YouTube channel. Today we have Senior Advocate Harish Narasappa sir, who has graciously and humbly accepted our invitation to be here and tell us about his life journey, how he chose to become a lawyer and how he has achieved so much in his life. So sir, most welcome and thank you again for being here. I would start with a very simple question and would love to understand how you started on your journey of choosing law as your career to becoming a senior advocate. And if you have faced any challenges, how did you come ahead of those challenges in your initial stages while pursuing law as a profession?
See, my journey with law actually started as an accident. I didn't choose law consciously. I think during my 12th standard, that was the time when the Mandal Commission report was implemented by the then Prime Minister, VP Singh. And post that, there was a lot of agitation by various student groups. And there were a couple of deaths as well. One student tried to immolate himself. So it had a deep impact on me in terms of what was happening in society. And that's what prompted my interest in something other than science. I was a science student, and there was a botany professor I had as well who sort of asked all of us to look at what's happening in society and not just worry about our books all the time. So that's what sort of triggered an interest in social affairs and what law potentially can do. And it also so happened, connected to the same incidents, the entire examination for that year was delayed. And by chance, I happened to write the entrance exam to the National Law School. And they announced the results before the engineering and medical college entrance examination results. And instead of sitting at home, my uncle told me, why don't you join for a couple of months? And if you don't like it, by that time, the engineering and medical college results would have come and you can quit and join engineering or medicine. But famous last words. So I joined and then I didn't leave even after the other results came. So in short, I joined the law for a month, but I have now been in the law for nearly 30 years.
What a beautiful journey, and the way you have put it, it is really fascinating that you joined law for a month, but you ended up being here for more than 2 decades with such a diverse background, with such a diverse journey that you have taken through different continents. We would love to hear about your insights that you have gained through practicing law in both India and UK. What kind of differences have you seen or encountered in these two legal systems and the kind of jurisprudence that these two states or jurisdictions have nurtured for themselves?
So comparison, there are two or three comparisons, right? One is the legal system, of course, but also in connection with how the legal profession is organized. And because we started, when we were chatting before the formal interview about how do we train youngsters, how do we train people who are just starting in the legal profession, how do we sort of help each other, how do we train each other? All these are important questions, and I feel that in India, we have not addressed these questions. And if you ask me, the primary difference between the legal profession in England and legal profession in India is the organized training and organized knowledge sharing that happens in UK. Primarily England, because I worked in London and not in other parts of the UK, but I worked in London. And if you compare that to what happens in India, I mean, in India, there's no organized system, right? You just pick up as you go. And if you're lucky, you get seniors or mentors who will teach you the right things. Otherwise, it's just hit or miss in terms of which office you join, what you learn in court or whatever. Nobody points you in the right direction. And there's no continuing legal education in a formal fashion. Whereas in England, they're a very organized set. So I worked in a law firm for about 4.5 years between 98 and 2002. And the things that I learned there have stood me in great stead over these years. They have helped me a lot. For example, drafting, simplicity in drafting, use of simple language is something that I learned in England. And it gave me the confidence that you're as bright as any other lawyer in the world. And with the right amount of training and the right focus on what to read, what not to read, you can do much better. And the other thing that I learned in the UK is how do you transform a sort of non-legal idea into a legal document. So drafting a legal document, whether it's an agreement or a plaint or a counter objections or anything, how do you make it simple and how do you get people to read it? So that's it. The training that the English law firms, the training mechanism that the English law firms in particular and the English legal profession in general, the way they have instituted it, I think that is something amazing. And we have a lot to learn from that. I think corporate law firms now in India, some of them have these kind of mechanisms, but they're still evolving. Whereas in courts, in litigators, among litigation lawyers, there's hardly any formal training. And you're expected to look, learn, and absorb. So I think that's a primary difference. And that also transforms into the legal system itself. That kind of training, that kind of knowledge sharing transforms into the legal system. And the UK is a more predictable legal system compared to ours. I think we have a very dynamic legal system, and I'm being very, very kind to our own legal system when we say we have a very dynamic legal system. So I feel there's a lot that we can learn from the English legal system in terms of organization and knowledge sharing. Like the firm that I worked for, I think had pretty much all the documents, every opinion the firm had issued for almost 30 to 40 years was available on their internal system. And you could just research and understand. So if you're faced with a difficult question and you're not able to find the answer amongst your colleagues or in a textbook, all you have to do was look into the firm's own history and you would find the answer. And that is something we don't have here. Partly because law firms are a new thing in India. I mean, they're only about 20, 25 years old in terms of large law firms. And the way the knowledge is shared and transferred, as I said, it's a hit or a miss, right? If you get lucky and get a good senior, then you learn. Otherwise, you learn to swim on your own. And that's the difference. So even when I and a couple of friends started Samvad, that's something we tried to inculcate in the firm. Even when we were just a 4-lawyer firm, we used to have knowledge sharing sessions amongst ourselves. And as we grew, I think it was set in stone. So that was non-negotiable. I think every one day of a week for about an hour, hour and a half, the entire firm used to gather. Even now they do. I mean, I'm no longer involved with the firm, but even now they do. And it's across offices now, of course, through VC and others, it's easy. And either somebody is talking on a topic or they share what's happening on different transactions in terms of knowledge, what's happening in court. So they share various things. I think that is a critical aspect. And I know now that a few other firms also do it. But we need to go beyond that, right? We need bar associations and bar councils to organize these sessions. Every month, there should be some session or the other for lawyers to attend, lawyers to learn. Simple thing like how do you dress, for example, in court. I see a lot of young lawyers, they wear shoes that are unpolished, they wear the socks is different, the color of the trouser is different, the color of the shirt is different, your hair is and whatever, right? I mean, you can express yourself differently, but nobody has taught them. Nobody in law colleges tell them how to appear in court on day one. Now there are a lot of videos from different courts where judges are shouting at young lawyers like, you don't know how to address a court, you're not dressed properly, what is this? I think these things can be avoided. And I feel bar associations and bar councils can take the lead, but they don't do it, unfortunately. And then also organize training on where to research, how to research. These are things that are easily possible, but are not done. And I think that's the biggest difference between the English legal profession and the Indian legal profession.
That is something which I also have faced a lot many times, that yes, people are not properly dressed. Many a times they do not know how to even address the court or the seat itself. All those things become so, I would say in simpler words, unacceptable at times, that you have gone through this long journey, you should have at least learned this. Yes, truly said that obviously it should be done through bar council as well as the colleges. So from hearing what you have said, I can understand what may have prompted you to start Samvad Partners and Daksh. which is basically the legal research organization that you have promoted and you have worked for so long. What was the reason behind you writing the book Rule of Law in India, A Quest for Reason? Was this the reason, or how did you find yourself getting that understanding of distinction between legal ideals and their practical implementations in India? What was the spark behind this? Because what you are saying, it is going to have an immense impact on the students, to be very frank. They need to hear this.
The challenges that the Indian legal system faces are actually evident all around us. And this is an example that I give very often. Why don't we, for example, just stop at red signals? Why are we so indisciplined when it comes to even basic legal norms? Why are we not able to follow it? And if anyone who has traveled to different parts of the world will know that we are unique that way. I'm sure there are a few other countries also where people behave badly in traffic, but jumping signals, people driving on footpaths, these are things that, and this is something that benefits everybody. I mean, there's no selfish interest there. And if everybody follows the traffic rules, all of us will get to the destination much faster. But we don't do it. There's chaos on our roads. And that chaos on our roads, in my view, symbolizes the chaos in all other aspects of the law. And we have quite a weak implementation mechanism when it comes to the law. And this is also evident in our courts, given the number of cases. There's so much activity going on, but very little result coming out every day. In the sense that chaos and confusion is the norm, not necessarily organized in a proper fashion. So this sort of contrast between everything written well in the law, and this is the other thing. If you read our legal books, legal texts, statutes or rules, by and large, we have everything. It's not as if we don't have good laws. We have good laws. Yes, there are exceptions, we challenge constitutionality, etc. But the intent to make a rule of law govern society was always there from 1947. But in practice, there are a lot of challenges. So this dichotomy between what is on paper and what is in reality is what prompted me to explore that. And when I started researching, then I realized that, at least in my view, what we're talking about is, among other things, is the lack of respect for the rule of law, whether it's from individuals, whether it's from government, whether it's from political parties, whether it's from the police, to some extent from some parts of the judiciary, depending on which judge, which officer, etc. Respect for the law is something that is lacking for various reasons. Okay. And that's what I want to explore in the book. To some extent, it was an evaluation of the dichotomy, and to some extent, it was an exploration of legal theory as to what does rule of law in India mean, and what kind of rule of law does the Constitution of India have. So that was something that I was doing for a long time. Then I decided, okay, let me try and write it down. And that's how that book came about.
Thank you, sir, for bringing up all these very important and pertinent points, because they have to be there. People have to understand why they have to respect rule of law or law itself. And there is a gap, definitely, and everyone is facing some or the other issue related to this particular problem of being defiant of law or not trying to understand why we need to follow law. So, sir, while doing all this, you also went ahead and did your master's in Oxford University. What was the difference that you saw while you were pursuing your postgraduate over there, and the difference between NLSIU in India and the systems which are followed by Oxford? And what difference did it make in your approach of understanding law and academia at the same time?
See, I think, again, to be completely honest, Oxford also was an accident. And many of my friends were applying to study masters, so I also applied. And thankfully, I got a scholarship in Oxford, which is why I chose Oxford and not some other university. I came from a modest financial background, and I'm the first generation lawyer that way. So there was a full scholarship available, and that's why I chose Oxford. But again, I'll be candid here. I've always felt that I gained more from National Law School than from Oxford. I've said this in many other places also. But probably because, and I don't know whether people still have the same experience, it's for each one to speak for themselves. But probably because also I joined the National Law School in its very initial phases. And we had a great set of faculty. We had an inspirational director, Vice Chancellor, and we had some great, excellent faculty members who actually gave a lot to the university. I think what we learned in the class and outside the class from talking to our teachers was extremely significant. There's a big sort of growing up. I mean, we were all a family, teachers, students, everybody in the first 5-6 years. And we thought it was a new experiment, so we were all trying to prove something. So we had a lot of pride and drive to show that this new experiment should succeed, kind of thing. But in Oxford, I think the difference, and this is the one big difference, the depth of reading that you're expected to do for a class was much. So in a master's course, obviously the depth is much more. But NLS was more focused on creating lawyers. Oxford was not, the master's course was not focused on creating lawyers. It was more knowledge. So just as an example, I remember I had taken jurisprudence in Oxford. Oxford, some of the greatest legal philosophers ever produced in the Western world. And in the jurisprudence, I remember going into the class for the first time, and I had seen the reading list. Then when I entered the class, did I realize that the expectation was you had read the entire reading list. Not just excerpts from the books, but the full text. So you should have had read Raz, Walk-in, all their books, and not just paragraphs from, say, Lloyd's Jurisprudence or some other book. So the expectation that you read was much more. That was a significant difference. And otherwise, the teaching approach was pretty similar. But of course, see, Oxford and Cambridge are the only, and I think there's probably one or two more universities, are the only two universities to have what is called tutorials, even now, where small groups of 3 to 4 students sit with a professor and there's an in-depth discussion of every problem, every topic. And that is a unique system. And in hindsight, I feel that maybe I should have spent more time at Oxford. I only did 1 year master's course. I probably would have benefited more from Oxford if I had been there for 2 years. But going to a place like Oxford, which had been there for like 500, 600 years, compared to NLS, which was 5 years old when I joined. So it was a lesson to be learned in institution building. And how do you keep a level of excellence for so many centuries? And what does it take to continue that commitment to excellence? And I think that is something that has stayed with me, along with the law that I learned. So because you asked what is the difference, I think the ability to go deep into a problem is something that institutions like Oxford teach you. NLS taught me great fundamental principles of law. And that is what I tell many people even now, many law firms and lawyers, when they say, oh, the first year student, he does not know how to draft a contract. I said, that is not what he or she is supposed to have learned in law school. I would much rather that the student have learned fundamentals of contract. Like, what is a contract? What is consideration? To draft something, you can teach the young lawyer, but you can't teach them fundamental principles of law. And I think that's what law schools should focus on. At least I am not a big fan of specialized courses in the undergraduate course. Master's course, I can understand. But in the undergraduate course, in the third year, I get interns who say, oh, I want to do AI and the law. I mean, I said, okay, but first of all, you need to understand what are your fundamental principles. So what are the principles of contract? What are the principles of company law? What are the principles of income tax? Or what are the principles of constitutional law, criminal law, whichever area you go to? I think that good grounding in fundamental principles is what NLS taught me, and that has played a part in my legal journey. And Oxford, because you have many international students, you learn about their legal systems, and the seed for evaluating the Indian legal system and for my book, I think was sown in Oxford. When you compare other legal systems, right, your friends from Germany or France or US and UK talking about their legal systems, and then you realize that your legal system is somewhat different. And you want to understand why. And I think that's sort of leads to it.
I guess, sir, comparative study is absolutely important, even to evolve as an individual also. Even if you don't take the community itself, we have to think about understanding these things. I guess that is where I think IIT is also nearly similar, and they teach us a lot of comparative study. That's something which I learned in my days. And when we were talking about NLS and the way you studied things in Oxford, I could relate that when you read so many case studies, you learn so much and you understand the basic concepts of those. You can always find a niche after that and find in masters and in your PhD, which you also have done. Sir, I would like to now ask you about when you became a designated senior advocate, the kind of advice which you would like to give to our aspiring lawyers who are trying, or I would say who are looking to make an impact in the legal field as you have made. Maybe they can try. What would be your advice?
See, there's no clear path or road to success. You need to follow your own path. You need to follow your interests. And there's no substitute for hard work. That I think everybody keeps telling that, and I fully agree. You have to work hard. There's no shortcut, unfortunately. Yes, you need to develop a few more skills because now the profession is competitive. The clients can easily find out about your reputation, about your other peers who also have a reputation in the same area that you're working in. And getting clients and getting legal work is challenging. It's not easy unless you're part of an establishment and that establishment supports you. Then you have time. But if you're an individual lawyer with a solo practice, then you have to follow your interests, do things that interest you, develop an interest outside the law as well. For example, if you have an interest in environment, or you may have an interest in AI, since we talked about AI, or computer, learn that. And then you don't have to give up the law, but marry the two, try and marry the two. So you don't treat your legal profession as something only sitting in the office and reading case laws or judgments. Law is a profession that is rooted in society. So you have to see what's happening around you in society and try to interact with people in other professions, people in civil society. You may have cousins who are computer engineers, software engineers, talk to them, understand different things, expand your horizons. So hard work, expansion of horizons, reading, and follow your heart, follow your passion. And there's no one road to success. I think you'll get there eventually, but do what you like, not because what other people are doing, but because what you like.
So we have to follow our heart, definitely, sir. That's something which is a very key point, which people during the course of career, any career they choose, they tend to forget because we tend to follow the herd most of the times and we usually forget that. So that being said, you have been working, you have already worked as a partner in law firms and as an independent practitioner also. What kind of differences have you observed in the kind of work culture these two roles had? And particularly when you became a senior advocate, there must have been different kind of responsibilities and kind of domains must have come where you had to find new ways to take care of those responsibilities also. So how have you adapted those changes in your life professionally mostly, and what kind of journey you have had through all this, going through more than 2 decades now?
Being a partner in a law firm, you have to work in a team, right? You're building an organization. It's not just about you. And you have your other partners, you have junior colleagues. A law firm is also an organization. While it is a profession first, it's also a business. If you have hired a lot of juniors, if you have hired a lot of colleagues, then you need to keep the firm running. They're also a business, right? They need to make profit. And as I was telling you earlier, one of the key things for a law firm is to organize itself. So good organization, not only in execution of the work, but also in HR, in accounts, in business development. There are many things to a law firm. After I've become an independent senior advocate, well, the only people you need to impress are other lawyers because they're the ones who come to brief you. What I miss about being part of a law firm is the collegiate atmosphere. Now, in my office, I only have one or two juniors, and that's it. And the other lawyers come to brief me. Of course, now you have a much wider interaction with the legal profession, but the collegiate atmosphere of a law firm is what you miss. Yes, in courts, you see other lawyers, you chat to them, but everybody is busy. We're running from one court to another, one court hall to another court hall. At best, if you're lucky, you catch your friend for a coffee in the court canteen, but that's about it. Whereas in a law firm, people used to walk into my room all the time and ask me if they're facing a tricky question of law. They used to chat to me, ask, okay, what should I do? How should I address this situation? Or a client is being difficult. How do I deal with it? So that kind of informal learning is what I miss being an independent senior advocate. You learn watching others in court, but this collegiate atmosphere is something you miss as an independent practitioner. And also, if you're sick, that's it. Somebody else has to do it. There's nobody to step in for you. For the senior counsel, it's different. The briefing lawyer is there, he can take care of it. But if you're an independent practitioner who has a solo practice, if you're sick, then your client's matter gets affected. So those are the challenges with an independent practice. In a law firm, there's somebody else who can pick up the matter and run with it. So the organizational dynamics is something that I miss as a senior advocate. But as a senior advocate, you get to deal with interesting problems because the assumption is people come to you with problems that are difficult or matters where the stakes are high. So in a way, now you don't deal with the regular run of the mill problems which you dealt with as a partner in a law firm. And you're insulated from the client pressures to some extent. If you mess up in court, the clients are not going to forgive you. I feel that being a senior advocate is a sort of more pure form of the practice of law because you're literally dealing with questions of law. You're supposed to read more and become more of an expert who is able to guide a wider set of lawyers and deal with a wider set of problems. So I'm enjoying that aspect. While I miss the collegiate nature of a law firm, I don't miss the pressures and pulls that come with being a law firm partner. Instead of that, I get to focus more on pure questions of law now. So that is certainly more interesting and more challenging, at the stage where I am in my profession.
Thank you for sharing so candidly about how you feel being a senior advocate from being a partner to an independent solo practitioner. So you have made your name in commercial arbitration. I would say that's your niche, and you have found that space for yourself by working for so long and so diligently. What kind of misconceptions have you seen that people have related to arbitration? And how do you address them when it comes in front of you, or maybe someone is apprehensive about those understandings? Would you like to suggest some pointers or maybe your own experience?
I won't say misconceptions. See, if you're dealing with large commercial organizations and they're dealing with arbitration, everybody pretty much knows what arbitration is about. So, in terms of clients, I think they know what arbitration is, they know what they're getting into, all of that. I think the challenge with arbitration in India currently is, and this, I'm quoting Justice Ravindran, who is one of the best arbitrators of this country currently. I think in a conference, he was saying that what he finds as the biggest challenge for arbitration in India is the lack of professionalism. And I think I couldn't agree with him more. What does this mean? I mean, he didn't elaborate. Now, this is my view. He was pointing it out in different contexts. For example, arbitrations need to be held on time. They need to stick to the time limit which is prescribed in the statute. Then, if you are appointed as an arbitrator or you are counsel in arbitration, we forget that it is not just a private form of dispute resolution, but it is a serious form of private dispute resolution. Okay. For example, in India, we're still struggling with situations where arbitrators don't come on time. Other day, there was an arbitration at around 10:30. It was fixed for 10:30 in the morning, and we had all logged in. And the arbitrator had not logged in until 10:45. And then we'll get a message at 10:45 saying the arbitrator had fallen sick. Now, they could have easily informed us earlier. So we'd all logged in. Now, it raises two challenges. So what do I tell the client? Do I bill the client or no? Because I have not gone to another matter and I was waiting for the arbitration to start. So what do I do? That's a professional challenge, and we as lawyers need to understand that. But this is not just arbitrators. Even lawyers sometimes don't turn up at arbitration. They'll say, oh, he's coming another half an hour, another 45 minutes. I think these are the challenges that we are facing. Their awards are not passed on time. These are all challenges that we are facing as far as arbitration is concerned. And many lawyers think arbitration is also a sort of a diluted form of arguing disputes in court. They forget that regular provisions like the CPC, Evidence Act, and all need not apply. We can follow a procedure as long as natural justice is met. So people quote long and hard, long provisions from CPC, Evidence Act. Then cross-examination, they want to ask 600 questions, 700 questions. So the misconception that it's a substitute form of trial is something the Indian arbitration system needs to deal with. But I think the biggest challenge is improving professionalism amongst everybody involved: lawyers, arbitrators, then developing arbitration institutions, and hoping that we all learn better and to make it a more efficient system. See, because there are two challenges, Divya, in terms of the moment cases get taken out of the court system and are arbitrated, we are losing the jurisprudence, right? Because arbitral awards are not available in public. It's not published in SEC or AIR or whatever. And that is what's happening in most commercial disputes. So commercial jurisprudence is not becoming available to all the general lawyers. Only the small set of lawyers who are arguing arbitration cases are aware of that. So when we're doing that, we're taking away from the courts an enormous opportunity to develop commercial jurisprudence. Then we need to do it properly. We can't mess it up. So currently, because there are no, except one or two, there are no significant arbitration institutions in this country. Mostly we have ad hoc arbitrations. And they have become, unfortunately, very expensive, very long, and extremely unprofessional. So this is a combination of all the three things. Yes, things are changing now. There are a lot of people making a lot of effort to improve things, to follow professional organizations from other parts of the world, etc. But as I said, the examples in other countries have been around. Like I was talking about legal profession earlier. That has been there for a long time. Other countries have organized their professions much better. But we have not been able to do it. Those are challenges that we have not been able to overcome. And that, I'm afraid, and I hope it doesn't, is plaguing and probably continue to plague our arbitration system. So, well, there are no misconceptions, but people come rosy-eyed with rose-tinted glasses to arbitration thinking they'll get an award in 6 months. Sometimes it drags on like for 3 years, 4 years. And that's frustrating. So that is a challenge that we are facing in arbitration. But I'm hopeful of this because there are a lot of developments in the arbitration world in India. Hopefully things will improve.
I'm also very hopeful that what you are saying, it really takes place and people are not only on time, they are well read also. Because many times it's seen that they tend to not even read the cases, sorry to say, but that's what I have also seen sometimes. And since I am always interested in understanding how IP arbitration works in India, that's another thing which is not there. So yes, being on time will help a little. It will change from Indian Standard Time to real Indian Standard Time, hopefully sooner. So all this being said and done, we have gone through your professional life. How do you take care of your personal hobbies and interests and balance your personal life with the kind of busy professional life that you have outside the law? How do you do all these things, keep yourself calm and learn and understand how world works? Please tell us that as well, sir.
That's what all of humanity has been searching for, right? I mean, we've been searching for peace. From the times of the Buddha, we're all searching for peace. Apart from all that, I think you raise an important question. And I think Indian lawyers, in my view, work way too hard. For example, judges also, while we complain about the delays and all, I think Indian judges work extremely hard, and so do Indian lawyers. There's no respect for their own time. And it's something when we started Samvad, we were very conscious of. And Samvad has that reputation even today that it's a firm that balances work and life. And we were able to do that in that organization. But that comes with challenges. Young people want to make money because their peers in other law firms are making more money. So how do you deal with that? And it's a difficult conundrum in terms of whether you want to make money when you're young and save all the money for later and you don't know whether you will be able to enjoy, or you want to do it now. I mean, these are questions that are difficult to answer. I have been lucky in the sense that I've been able to sort of manage a reasonably good work-life balance. So two things are important. One, you need to enjoy what you're doing. Okay. And yeah, I know you asked me the question about Daksh earlier. The fact that I started Daksh at the same time as I started my law firm and I continued to be involved in Daksh, sort of encouraged me to spend more time in the profession also. So you should do what you're interested in. The fact that I was doing things beyond the pure practice of law and into policy research made me focus more on the profession also, because I knew what I was doing, what I'm able to do. So all that is important. And at the same time, along with policy work or legal professional work, having time for your family or kids and what you like otherwise is also important. So in a long way, I'm coming to answering the question you asked. I'm lucky to have a few things that I enjoy. I like running. I run regularly. I like climbing mountains. I do a fair amount of trekking. And my daughter started playing tennis, so I started learning tennis so that I can play with her. So I think simple things, if you focus on doing simple things, my grandfather, he's no more, but when he was alive, he was a farmer. So he used to talk to me about different crops, different fruits that he's growing. So pay interest. I think there are other things that are happening around you. I think we sort of sometimes get consumed by what we are doing, but pay interest and your hobbies will develop automatically. So I think those are the things that have encouraged me to refocus on work as well. And the only message that I want to give, I mean, since you said, how do other people learn from us and how do we learn from others? I think we need to see what other people are doing. Like I remember reading somewhere, Soli Sorabji, for example, was very well known in the jazz circuits, jazz music circuits. So there are different lawyers with different professions. Like the other day, I remember walking into some restaurant in a Bangalore that only does organic food and organic products and all that. And the owner was a lawyer. So you see that different people are doing different things and you need to learn from them. And if you have other interests, doing those things will also help you refocus and focus more and become more efficient in the profession, is what I feel.
Thank you so much, sir, for telling us such beautiful, not only stories, but realities of life. And it was really a humbling experience, at least for me. And I hope our learners and listeners will understand what you have told them are absolutely gems, and one has to understand why we have to be on time, why we have to be honest with our profession, why we need to understand to respect each other as professionals and in personal life as well. Once again, sir, thank you so much for agreeing and meeting with us and giving us such beautiful content and letting us learn from you. Thank you so much, sir.
Thank you for having me and thank you for interviewing me.